Thank you for that incredibly warm introduction. I'm truly delighted and honored to be here, and especially to be here to deliver the Derrick Bell Lecture. He is one of the real titans of the legal community. If you're teaching constitutional law and the Equal Protection Clause and you don't mention Professor Bell, Dean Bell's name multiple times, you're not doing your job in the right way. He belongs on a tiny list of names of scholars who must be invoked, right up there with John Hart-Ely, Alex Bickel, Charles Black. It's a tiny, tiny list, and Derrick Bell is definitely on it. He is, of course, the Jackie Robinson of law school deans, the first black dean to lead a non-historically black law school. And those of you who are baseball fans know that a lot of emphasis was placed on identifying the right person to break the color barrier with respect to Jackie Robinson. And the University of Oregon did itself and the nation proud by selecting Derrick Bell. I've read his work many times over the years, and it warrants reading and then revisiting. Different things jump out at me when I read Professor Bell's work. I find things that I agree with, sometimes things that I disagreed with, and then I read it later and I say, maybe he was onto something after all. It always generates a reaction, and that's legal scholarship at its finest. I first encountered Professor Bell's writing when I was an undergraduate in the early 90s. We read selections of Faces at the Bottom of the Well, his magnificent collection. And if you had told me then that I would be giving a lecture in his honor, I would have thought you delusional, or maybe that you had been abusing drugs. But I'm really honored to be here today. Okay, so I'm going to talk about the Supreme Court's decision, Students for Fair Admissions versus Harvard from 2023, where the Supreme Court invalidated affirmative action policies. I had another book project that I was working on at the time as this case made its way to the Supreme Court. I felt compelled to set aside that book project and to focus on this decision. I think it's deeply misguided, but I also think it's deeply misunderstood. And I think that there's a lot of value that can come from trying to understand what the decision said and also what it did not say. Because while I think it was wrong-headed, I think that there are many things that remain available for universities and the world at large to pursue in the name of racial justice. It seems to me that this is an important decision in the realm of higher education, but its influence extends well beyond that, in part because, in my estimation, the Trump administration is brandishing a misapprehension of what the decision actually says in a way to extend it into lots of different spheres, including elementary and secondary schools, the business world, the world of nonprofits, and on and on. So this is an incredibly significant decision. I'm going to talk for a while, and then I look forward to your questions, your comments, and your objections. Okay, so one of the things I'm trying to do in the book is to salute affirmative action for the incredible work that it did in promoting racial justice. It seems to me that affirmative action represented an assault on the prevailing racial hierarchy of the United States. The Supreme Court repeatedly has entertained challenges to affirmative action, and for a long time it upheld the constitutionality of the plan. It often did so through gritted teeth with deep ambivalence. And so one of the things I'm trying to do in my book is to say we should get beyond the ambivalence. You can see the ambivalence in Justice Powell's controlling opinion in the Bakke decision from 1978. You can see it in my beloved old boss's opinion for the court in the Grutter decision in 2003, Justice Sandra Day O'Connor, of course. And you can see it in the Fisher opinions as well. So what did affirmative action do? I want to offer some statistics. The fall of 1960, the entering classes of Harvard, Yale, and Princeton included about 3,000 students. A grand total of 15 of those students were black. Harvard had 9 black students, Yale had 5 black students, Princeton had a black student, the one. You flash forward a decade to 1970, still about 3,000 students entering those exceptional colleges, and just shy of 300 students were black. So we go from about 0.5% in 1960 black to just shy of 10% black. Again, that seems to me to be a significant transformation that spilled over throughout our professional world, thinking about medicine, law, engineering, academia. This is a significant event, and it seems to me that affirmative action belongs right up there with the GI Bill of Rights, as the GI Bill as a significant transformation, admirable thing that should be saluted. In the aftermath of the court's decision, many universities, of course, experienced profound declining enrollment rates for black students. MIT went from 15% black to 5% black. Amherst College went from 11% black to 3% black. And many institutions experienced similar declines. So it seems to me, I fear that we are seeing, or perhaps more accurately not seeing, a lost generation of black students at many institutions. I'm trying to do a few different things in the book. One is to challenge conservatives. Another is to challenge my fellow liberals. With respect to conservatives, conservatives have been pining for the end of affirmative action for a very long period of time. And in the book, I argue that even as assessed by conservative lights, the SFFA versus Harvard decision creates a less desirable admissions regime than the one that it replaced. This is a counterintuitive argument, to put it mildly, but I believe it. So in here, I really do try to take conservatives seriously, try to take seriously the arguments that they make against affirmative action. And I think that the decision is going to have perverse effects. Let me give you a couple of different examples. One of the primary arguments against affirmative action is that it promotes an idea of victimization, a cult of victimology. This is an argument that I associate with Shelby Steele. Justice Thomas has made arguments in this register as well, that it's a dangerous thing if you're trying to make a contribution to society to portray yourself as a victim. But the new regime, the post-SFFA regime, is actually heightens victimology concerns rather than diminishing them. And let me tell you how that works. So after SFFA, colleges and universities have precluded themselves from being able to access the racial checkbox data that used to exist all the way through the admissions process, including admitting people off of the wait list. Under the old regime, a black applicant like myself could check the black box and then write a personal statement about why I wanted to study Proust or Plato or anything else under the university's wide sun. But because universities cannot access that racial checkbox data, black applicants are incentivized to write essays that sound in racial victimization. At the very end of Chief Justice Roberts' opinion, he expressly says universities can consider individualized essays that speak about their experiences with racial discrimination He says racial discrimination, inspiration, and otherwise. I think that applicants are feasting on discrimination and setting racial inspiration aside, in part because a successful college application essay needs some friction. You need to be pushing against something rather than saying, we would get together on these nights and sing our traditional songs. That's not going to get the job done in the ultra-competitive world of college admissions. And I talk to my students about this phenomenon, and they express deep resentment at what they refer to as performing their trauma, being required to go through these particular items. And, of course, conservatives, and this is a view that I share, though I do not style myself a conservative, race is not the most important thing about us. It need not define us along every respect. However, when colleges frame admissions essays in very open-ended ways, but the cue is you're supposed to write about your racial trauma and your racial grievances, that succeeds in instilling the notion that race defines who we are. As you all know, in order to get admitted, you have to write an excellent essay, one that requires multiple rounds of revision. And it seems to me that students are going to lug their senses of aggrievement with them to campus right along with their dorm refrigerators. Okay, so that's how victimization is going to increase. Let me give you another example. Many conservatives say the problem with affirmative action is that it creates mismatch. This is a term that Professor Richard Sander of UCLA Law School introduced, although the idea goes back to the dawn of affirmative action. Sander started talking about this sort of 20 years ago or so. But this goes back to the 1960s. My former colleague at the University of Texas School of Law, Lino Graglia, writes one of the first critiques of affirmative action in the 1960s, and he says, the problem with affirmative action is that it promotes people into academic environments for which they are ill-prepared. They're not going to succeed. Rather than going to this, rather than going to this school, black applicants instead are sucked up and they're going to be promoted to this school and they're not going to be able to make the grade. So I try to take this mismatch idea seriously. I focus on what I would refer to as social mismatch rather than academic mismatch. And this is an idea that our own Justice Clarence Thomas has promoted both in his memoir, My Grandfather's Son, and also in interpersonal communications. I write in my book about an encounter that he had with a young man from my hometown of Washington, D.C., called Cedric Jennings. Cedric Jennings went to Ballou High School in Washington, D.C., an underperforming urban high school with an entirely black population, and this is a young man who's trying to achieve in the face of real adversity. Ron Suskind, a journalist for the Wall Street Journal, profiled Cedric Jennings, and to Justice Thomas's credit, Thomas reads the Wall Street Journal and issues a standing invitation to Cedric Jennings to come visit him in chambers anytime that he deems fit. Eventually, Jennings takes him up on the invitation, and Suskind accompanies young Cedric Jennings to the Supreme Court of the United States. Eventually, the topic of college plans comes up, and Cedric Jennings says, well, I'm off to Brown University in the fall. Justice Thomas frowns, shakes his head, and looks at the ground and says, I don't know if I would do that if I were you. I'm paraphrasing here. There are a lot of smart white kids up there, and if you're not sure who you are, you could get lost. This was not an offhanded comment. As I said, in My Grandfather's Son, Justice Thomas spoke about his own experiences attending Holy Cross. And he says that I saw a lot of black kids who'd never been around white people. They weren't sure who they were, and they ended up with real problems. So how does mismatch get heightened under the new regime? It's going to be easier for many elite colleges to admit the valedictorian of the Ballou high schools of the world rather than the A- student from some of the finest schools in the country. And it seems to me that this mismatch phenomenon, the Blues being non-racially diverse environments, are going to be difficult. Again, I'm trying to channel my inner Wall Street Journal editorial writer. One last example, another thing that people talk about for conservatives is an idea that's referred to as balkanization, that the problem with affirmative action is that it sows the seeds of racial resentment. People learn about these programs, and it leads to real sort of bitterness. And here, people are speaking, largely about white applicants. But there's a really curious part of the opinion that Chief Justice Roberts wrote. Footnote 4 of the opinion, he offers an express carve-out for the nation's military academies, thinking about West Point and Annapolis. That may be a different kettle of fish, Chief Justice Roberts says, so we need not reach this. That phenomenon is going to result in sowing the seeds of racial resentment, especially among black and brown people. In my book, I quote a graduate of West Point, a black graduate of West Point, who says the following: affirmative action is good enough for black folks to die on behalf of this country, but it's not good enough for black folks to have access to becoming among the best lawyers, teachers, doctors, engineers, artists that this country has to offer. I can die for this country, but I can't learn and instruct and save and build. And it felt like a direct slap in the face, talking about the judicial opinion. And it was very disappointing and disheartening for me because I asked myself, man, what was it all for? Why did I serve if I'm only looked at as cannon fodder? Be hard-pressed to identify a better example of sowing the seeds of racial resentment than that right there. Okay, that's my challenge to conservatives. My challenge to liberals involves the traditional dichotomy of the Equal Protection Clause. You constitutional law students know that there are two dominant understandings of what the Equal Protection Clause prohibits. On one account, it prohibits racial classifications. This is an idea that is overwhelmingly associated with conservatives. And on another account, the Equal Protection Clause prohibits racial subordination. This is something that liberals favor overwhelmingly. And so on the conventional liberal account, people would say, well, the problem of, say, Brown versus Board of Education is that it involves both racial classifications, so conservatives think Brown's correctly decided, but many liberals would say, yeah, but the real problem with Brown versus Board of Education was that it was predicated on Jim Crow and a theory of black inferiority. And so the rubber hits the road with this dichotomy when it comes to affirmative action. My fellow liberals overwhelmingly have said, oh, affirmative action, that's no problem whatsoever. That passes constitutional muster because it was not about thinking that black people are inferior. It's designed to lift people up rather than, black people up rather than sort of set them apart. It's a very intriguing theory. It dates back to the 1970s. It's sort of pioneered by my colleague Owen Fiss, my colleague and friend. However, I wrote an article, it's the spine of chapter 2, that's titled The Strange Career of Anti-Subordination, and I suggest that that terminology, that idea, is a good bit more indeterminate than is commonly understood. Fascinatingly, Justice Thomas used the term anti-subordination for the first time in the U.S. reports in his concurring opinion in SFFA versus Harvard. And he says, in effect, he actually purports to be at war with this anti-subordination idea and says, I believe in anti-classification. But throughout his writings, he says the problem with race-conscious programs is that they are predicated on a theory of black inferiority. That these programs that were designed to promote racial integration in Missouri in the 1990s is that they give voice to the lie that black people can't learn when left to their own devices. And that's the same problem with affirmative action, Justice Thomas would say. They think that black people can't make the grade without a booster seat. You don't have to take it from Justice Thomas, however, that there can be a subordinating component of affirmative action. You can take it from none other than Professor Derrick Bell, who wrote a fascinating essay in the 1970s, and he says that one thing about affirmative action is that it envelops minority applicants in a cloud of suspected incompetence, he says. That is classic subordination language. So, and Professor Bell is not alone. As Professor Randall Kennedy of Harvard Law School has written a book about affirmative action that says, yeah, there is a subordinating component to this. I still defend affirmative action, Professor Kennedy says. But yeah, there is a subordinating component, and my colleague, Professor Stephen Carter, wrote a book called Reflections of an Affirmative Action Baby, and that is the dominant through line, that there is this subordinating component. Again, Carter would say, I defend affirmative action, but this idea that there's not a subordinating component is incorrect. And so I don't think it will do for liberals to simply pound their fists on the table and say anti-subordination, that's why affirmative action is A-OK. It's more complicated. I suggest in the book that it would behoove us to spend some time thinking about what the Equal Protection Clause requires rather than only thinking about what it prohibits. Okay, so now I am going to spend some time trying to identify what remains available to universities who are interested in enrolling racially diverse classes. My first book was about students' constitutional rights in the elementary and secondary school context. And I view that book as an inquiry into the way that the Constitution assumes a particular form in various institutional settings. So there is a Constitution that exists within the public school that is different than when minors are in the public park across the street after school. I've also done some work about writing about the way that the Constitution assumes a particular form in prisons. So this is what I think of as the sites of constitutional interpretation. Rather than saying, well, does the Constitution protect this? One of the more important questions is, well, where did the conduct happen? One way to understand SFFA versus Harvard is that it harmonizes the Constitution in the elementary and secondary school setting with the Constitution in higher education. When I was a law clerk for Justice Breyer, there was an important case that was decided called Parents Involved in Community Schools, 2007, dealing with voluntary racial integration programs. And the court invalidated that plan, those plans that were under review, because they involved individual racial classifications. Students checked a box. Justice Kennedy wrote the controlling opinion for the court, and he said, well, yeah, the problem with these is that they involve racial classifications, but, Justice Kennedy said, I don't believe that school districts need to be completely colorblind. Justice Kennedy says, school districts can be aware of how they draw particular boundaries with an eye toward promoting racial diversity. When they are deciding where to build a school, they can be aware of the racial demographics for pursuing racial diversity. And I would say that that's what we can understand SFFA as doing as well, importing Justice Kennedy's controlling opinion in Parents Involved to the context of higher education. When Chief Justice Roberts wrote the plurality opinion in Parents Involved, he said, oh yeah, there's something about Grutter and affirmative action, but that was higher education. We're dealing with, in effect, lower education. And so it's a different kettle of fish. But you can understand SFFA versus Harvard as bringing these things into concert. So Chief Justice Roberts says, my best reading of the opinion is that what's prohibited is considerations of race qua race, he says. Race for the sake of race. And one way to understand this is that it goes to individual racial classifications, the checkbox data that was at work. You know that Chief Justice Roberts does not think that all considerations of race are prohibited, otherwise there wouldn't have been that carve-out with respect to essays. So I think that there is a good bit more room available for universities who are interested in pursuing racial diversity than is commonly understood. And you don't have to take it from me. You can take it from none other than Antonin Scalia, the most influential Supreme Court justice of the last 5 decades. Who's ever in second place, it's a distant second. I say that not because Justice Scalia is my guy, he ain't. I say that as a descriptive matter. He has changed how we talk about the law. A majority of the current Supreme Court marches behind an originalist banner, and that is in no small part due to Justice Scalia's influence. Textualism reigns supreme at the Supreme Court. So he really has shaped things. When he was mere Professor Scalia rather than Justice Scalia, he wrote a very interesting, almost completely forgotten law review article. It's in the Washington University Law Quarterly, right after Bakke. And he says the following, and I hope that those who revere Justice Scalia will take him seriously. He says, he has no problem with programs that are designed to help what he refers to as the poor and disadvantaged. He goes on to say, it may well be that many or even most of those benefited by such programs would be members of minority races that affirmative action favors. He goes on to say, I would not care if all of them were. The all is emphasized in the original. The unacceptable vice is simply selecting or rejecting them on the basis of their race. Again, the italics is his, not mine. Another way of understanding that is that he's saying what's forbidden is race qua race. So, what can we do with race qua race? And before I go any further, I want to emphasize that what I'm about to say is not in the name of defiance of the Supreme Court. There are people who have written in this area and say, I don't care what the Supreme Court did, they should just continue doing whatever they were doing before. I am off team defiance. We have a history of defiance of the Supreme Court, and it's an ugly one. Okay, what remains available? I'll start with the most provocative idea. Preferences for slavery's descendants. Okay, this is crazy. How can you get there? Originalism, which I just gestured toward a moment ago. It's a fascinating question. If you are an originalist and you are opposed to affirmative action, what do you do with the Freedmen's Bureau? If you're an originalist, of course, you are interested in what the Constitution's original public meaning is. And you care about contemporaneous understandings of that would have existed at the time of the ratification of the 14th Amendment's Equal Protection Clause. And this issue arose at oral argument when someone asked a question about whether preferences for the descendants of the enslaved would be constitutionally permissible. And the lawyer who was attacking affirmative action suggested that it would not be permissible, and the issue of the Freedmen's Bureau came up. The attorney says, well, okay, hold on. The Freedmen's Bureau, that wasn't a racial category. That wasn't a racial designation. That was a designation that went to the status of having been an enslaved person. Now, many historians, including the mighty Eric Foner, think that this is a laughable understanding. that Foner would say the term freedman was synonymous with black people. These was the one and the same. Justice Thomas, to his credit, took up this question in his concurring opinion, and he says that is about the Freedmen's Bureau is about the status of having been an enslaved person, not a racial category. But that means that preferences for the descendants of the enslaved would also not be a racial category, and therefore would not be subjected to strict scrutiny. And bear in mind, what's prohibited is race qua race. There are, yes, many black people in the United States today who would be able to claim being a descendant of the enslaved, but there are many, many black people in the country who would not be able to claim that. That means that there are black people on either side of this line, and that's not race qua race. By the way, this isn't a totally new thing under the sun of American universities. Georgetown University has a preference for the descendants of the enslaved at the college. And I salute Georgetown for taking that step forward. Now, I wish that they would go further still, because they require people who qualify for this preference to be able to trace their ancestry back to being owned by, in effect, Georgetown itself. That's too parsimonious an understanding, in my view. One of the central horrors of slavery is that it turned individual souls into fungible commodities, and the presumption of fungibility should be extended in this realm as well. Preferences for the descendants of the enslaved is one thing that remains available to universities. Many universities, including my own, have done serious investigative work examining their ties and connections to the peculiar institution. A few of them have gone the next step and said, and we have a special responsibility to address that issue. Okay, next concrete topic and idea. Preferences for tribal members. There's an opinion dating back to the 1970s, Morton versus Mancari, that says preferences for tribal members are not racial designations. That is a political designation. It would be one thing if you were talking about preferences for Native Americans, but if you have a tribal membership, that is a different matter altogether. We do an inadequate job in these sorts of conversations of thinking about our Native American brothers and sisters, our brothers and sisters who are members of tribes. And universities that have gotten rid of affirmative action have repeatedly seen those percentages plummet. This is constitutionally permissible, it's not race qua race, and it's totally available. Third idea that is concrete and operationalizable. I would encourage universities to form partnerships with local schools that do not have a strong track record of sending students to the flagship university. Many universities have forged meaningful connections to especially elite high schools in the country. Why not attempt to foster connections with people from the not elite high schools of the country that, and especially those in their neck of the woods, that are often teeming, of course, with black and brown students. So I would encourage the University of Chicago to think about its own South Side. I would think about Georgetown's Southeast Washington, where I'm from, Stanford's East Palo Alto, and on and on and on. The ivory tower casts a long shadow over black and brown communities, and they should open their doors and welcome those students. Yale College, I'm happy to report, had more students in its first-year class from New Haven Public Schools than ever before in its history, and I hope that more schools will follow Yale's lead. Okay, next idea. What about class? That's an important consideration here. Many people who are skeptical of race racial affirmative action, race-conscious admissions, say class, not race. That's the solution. I am all in favor of offering a bump, a preference to people from modest circumstances, and that would include Appalachia just as well as Anacostia, section of Washington, D.C. However, I think that it is too crude just to say class, not race. If the issue were that easily resolved, for the people who say they're interested in enrolling significant numbers of racial minorities, California, which got rid of affirmative action in the 1990s, would have resolved that much more readily. They're not stupid in California, I can assure you. And nevertheless, they had real plummeting enrollments. Princeton's class of 2029 just announced its new enrollment percentages, and to their credit, they have more students from modest backgrounds than ever before, more Pell Grant recipients than ever before. That's wonderful. They also have fewer black students than they've had since the 1960s. So this idea that sort of a rising tide lifts all boats, nah, not true. So there's a wonderful publicly available device called the Opportunity Atlas. It's by economists Raj Chetty of Harvard and John Friedman of Brown. And they get census tract data trying to quantify the opportunities and, in effect, the disadvantages that various neighborhoods face by looking at incarceration rates of the neighborhood, teen pregnancy rates, and these sorts of things. And so I support universities having a quota, that's right, I said it, a quota for students from low opportunity areas. Within this quota, 10%, 20% of the university are going to be people who have grown up in really challenging circumstances. Within that quota, 80% of people are going to come from urban areas and 20% are going to come from rural areas. I haven't just plucked those numbers out of my hat. The Census Bureau tells me that 80% of Americans live in urban areas and 20% live in rural areas, and I believe that that would have a desirable effect, and that's not race qua race. The last concrete idea that I have for you all is a section of the book that I refer to as the fall and rise of box checking. So racial boxes, as can be accessed by universities, are gone. But one thing that could be a good idea would be to include many other boxes that would be able to be checked, that would be, I have no doubt, correlated with race, but are not themselves race qua race. Do you have a close relative who was incarcerated? Did your family rent rather than own their home? Were you born to unwed parents? On and on and on. One virtue of this is that it would lighten the burden on applicants from having to write yet another personalized essay. Universities would be able to access this information, and you could imagine many other boxes being added as well, and that would be a desirable thing. Let me tell you about one thing that I think is not going to work. And that's not going to work for purposes of enrolling significant numbers of racial minorities. Getting rid of legacy admissions. Let me be clear. I am opposed to legacy admissions. I said to the New York Times a while back that supporting legacy admissions is a little like rooting for Elon Musk to purchase the winning lottery ticket, Somebody who has everything doesn't need something more. It's objectionable, deeply immoral. My own children get very upset when I talk in this register, I should say. But this idea that if we get rid of legacy admissions, that all of a sudden we're going to have black and brown and Native students rushing to the fore is illusory. Several major universities got rid of legacy admissions before SFFA, including Amherst, Johns Hopkins, MIT, and all three of those places suffered declining black enrollment. So I'm all for getting rid of legacy admissions, but we shouldn't suffer under the delusion that that's going to address this racial issue. Let me just say two more things, and then I am going to end on an optimistic note. One thing that makes me wild about the opinion, I can't believe that it made it into the U.S. reports. It's very hard for me to take it seriously, but I would welcome pushback on this front, and you tell me I'm all wet. Okay, so dating back to the Grutter opinion written by Justice O'Connor, she writes in 2003 in upholding affirmative action at the University of Michigan Law School. She says, it's been 25 years since we first upheld affirmative action in Bakke. We fully expect that in another 25 years, affirmative action will no longer be necessary. Highly unusual, we have to say, from the perspective of constitutional law. It feels almost like a sunset provision that one associates with the legislature rather than constitutional law. Nevertheless, she wrote it, and I take it seriously. Indeed, Justice Thomas's opinion in Grutter refers to it as a holding. Justice Kennedy refers to it as a pronouncement. The very fact that it is unusual and joined by a majority of the court is suggestive that there was some purchase there. Indeed, SFFA's brief referred to it as a grace period. Chief Justice Roberts, in his majority opinion, and Justice Kavanaugh's concurring opinion, both said, we are honoring the 25-year sunset provision, which was confounding because, of course, 2003 plus 25 takes you to 2028. So they say, we're not overruling Grutter, we are honoring it. So this is the sort of fuzzy math that should embarrass, mathematicians everywhere. They say, well, the next college class that is going to be admitted to Harvard and the University of North Carolina will be admitted to the class of 2028. Therefore, 25 years has been honored. Surely, at a minimum, though, the court's decision applies to all of higher education and not only the colleges. And there are these things, I have it on good authority, at universities called law schools. And the JD degree takes 3 years to complete, by which account Yale Law School should have been able to use affirmative action for an additional year because we're paying attention to the class of 2028. And the business school should have been able to use affirmative action for an additional period because the MBA takes 2 years. So if it's the class of 2028, it should have been able to go on. They didn't mean that. It's significant, however, because it's indicative of the Roberts Court being in a hurry on these matters. Chief Justice Roberts enjoys a reputation as being an incrementalist, an institutionalist, someone who's attempting to move slowly. But in this arena, the Roberts Court is in a hurry. The second to last thing before I end with some optimism is the following. Justice Thomas, in his critiques of affirmative action, says in, say, Grutter, the difficulty with affirmative action is that some people, some black applicants, would have been admitted to the University of Michigan Law School even without consideration of race, but no one can tell who would have been admitted on their own merits, a word that I place in quotation marks, and who is admitted through the back door by the vice of racial consideration. He says, in evocative language, all are tarred as undeserving. It seems to me that he is setting up a default rule there, and we should invert the default rule. Rather than presuming that people do not belong, the presumption of competence should go the other way, and you should say, well, of course. By the way, I'm okay with the rebuttable presumption of competence. Sometimes people really don't have what it takes. But we shouldn't just presume as a matter of course that people did not make it there. And I would presume the presumption of belonging to the legacy folks and the donor class, even the athletes, rather than presuming that somebody got in only because of their prowess on the football field. Okay, optimism. Three different points of optimism. One, as a result of talking about this book, I spoke to a member of the Yale College class of 1969. And this is a black member of the class of 69. He talked about how when he showed up on campus, there were virtually no black students in the senior class. There were like 6 black students, and I think it was the class of 66. And his cohort had something like 90 black students. Again, transformation. This class of 90 black students at Yale College included Henry Louis Gates Jr., Sheila Jackson Lee, Kurt Schmoke, first black mayor of Baltimore, a leader in higher education, Ben Carson, mighty surgeon and cabinet member in a presidential administration, Linda Darling Hammond, who in the world of education, she's a Stanford professor, is a giant. Other People's Children, magnificent book. And a man called Anthony Davis, who won the Pulitzer Prize in music. The idea that these folks didn't bring something to Yale and didn't make valuable contributions to our nation is ridiculous. And so part of the point here is to say that, as the old maxim holds, talent is everywhere, opportunity is not. Just take a quick glass of water here. Okay, these days, people are really hunting for optimism. Many people are distressed with where things stand right now. One source of optimism that has helped me in my own moments, I try to be an optimistic person, but in my own moments of pessimism, involves the mighty Thurgood Marshall. Justice Marshall wrote very effectively about affirmative action, but here I'm thinking about lawyer Thurgood Marshall. And he would tell his law clerks, as I understand it, that when he was a practicing attorney in the 30s and 40s, that his best case was Plessy versus Ferguson, right, which upholds separate but equal. But he took it upon himself to wring whatever equality he could out of that decision. This is an important opinion that is part of the anti-canon of constitutional law. And nevertheless, he mustered the enthusiasm to be able to, and the optimism to say a better day is coming. Okay. The Trump administration recently did something that has been relatively quiet and underappreciated. And that is that it withdrew an appeal in the federal courts in the Fourth Circuit. Very quiet. It was written about in the New York Times at the end of January. The Trump administration brandishing, we should say, a misconception about what SFFA actually means. They've issued a number of these Dear Colleague letters that are anything but collegial. And they've said, if a university or a school makes a change with an eye on promoting racial diversity, if they get rid of standardized tests, and they're doing it to increase racial diversity, that violates SFFA versus Harvard. That's erroneous. They also issued a letter that said, a Dear Colleague letter that required institutions of education generally, elementary and secondary schools, to attest that they did not have DEI programs. And the American Federation of Teachers filed a lawsuit saying that this was a violation of, among other things, the First Amendment freedom of speech, and that it would succeed in chilling the expression that's available in classrooms because they defined diversity, equity, and inclusion in such a capacious way that it would not be clear to teachers whether they were in violation of this. The district court judge, Judge Gallagher, in the federal district court in Maryland, said that it violated the Constitution of the United States to require institutions to sign these letters. And they were joined by a little school district in Eugene, Oregon. And that is a testament to what can be done when you allow the legal process to play itself out. Many universities capitulated, and I wish that they had followed the lead of Eugene. Okay, the last thing I'll say, and then I look forward to questions. It seems to me that today the perils of acquiescence in the age of Trump are profound, and the promise of dissent is boundless. Thank you.
We will take questions. I do have a roving mic because we have an online audience. Anybody have a question?
Could you talk about the danger you see in jurisprudence regarding racial proxies being applied to some of the possible solutions you supplied? Anything to be done to safeguard the use of race-neutral criteria, for example?
Wonderful question. Thank you so much for asking about this very question. It's top of mind for me. It seems to me that the Supreme Court has never suggested that the Texas 10% plan violates the Constitution of the United States. And that's significant because, of course, the Fisher case brought the University of Texas's admissions scheme to the Supreme Court twice. And in each instance, the Supreme Court was not thinking about the Texas 10% plan. The Texas 10% plan, of course, says that at the University of Texas at Austin, if you are a member of the graduating class of a Texas public high school, you have a spot reserved for you at UT Austin. This plan came into being in the 1990s in the aftermath of a Fifth Circuit opinion called Hopwood, which got rid of affirmative action. And the reason that this plan was adopted was because of the persistence of racial isolation in schools. And so if you say that you're a member of the top 10% of certain high schools, you can be certain that those are going to be black and brown students. It's a fascinating program and involved a coalition of legislators from urban areas and rural areas that found common ground and said the University of Texas should belong to all of us, not just for fancy kids from suburban schools in Dallas and Houston. So the Supreme Court of the United States has never said that violates the Constitution, even though there are some law professors who have been pushing this idea that, of course, that violates the Constitution. They adopted that plan for racial reasons. And if you can't tell, as conservatives say, when a plan is adopted for benign reasons and when it is adopted for invidious reasons, that should fail constitutional scrutiny. It seems to me that there are some justices who want to go over that next mountain and confront that issue and say, yes, that violates the Constitution. I have in mind Justice Thomas, Justice Alito, and to a lesser extent, Justice Gorsuch. They have been issuing some dissents from the denial of certiorari regarding magnet school admissions programs in Thomas Jefferson High School in Northern Virginia And there's a case out of Boston, and there are a couple of other cases. But there's not been 4 people to grant certiorari to agree to hear this case. So, and I think that it is going to be very complicated for the Roberts Court to say that sort of disparate impact would be enough to violate the Constitution of the United States in this category. It seems to me that the people who are gunning for claims that these sorts of programs violate the Constitution are blundering in the sense that they are challenging opinions that have long been admired by conservatives. I have in mind Washington versus Davis from the 1970s, which says that disparate impact alone is not enough overwhelmingly to make out a claim under the Equal Protection Clause. I do not believe that the Roberts Court is going to say, well, wait a minute, we're talking about white victims here? Oh, that violates the Equal Protection Clause. So I may be naive, but we're not there yet. And the most important thing that I would say is that it's incumbent upon universities and institutions of higher education and nonprofits not to over-acquiesce and give up and say, oh, well, we know which way the winds are blowing here, and sort of expand the scope of SFFA versus Harvard. It's a horrible enough opinion without over-interpreting it. Okay.
Other questions? Otherwise, I'll go online. So your book situates SFFA in a long historical arc. Do you think the majority and dissent are operating with fundamentally different historical narratives?
It's a really good question, and the answer to that question must be yes. Justice Jackson wrote a powerful dissenting opinion that places the court's decision in 2023 in a much longer historical arc, talking about the gaps that exist with respect to health and wealth and a number of other dimensions. Justice Jackson is sometimes, more attuned to what was happening in the 1860s than people who are understood to be thought of as originalists more generally. As I said earlier, I was a law clerk when the parents involved case was decided, and Chief Justice Roberts wrote this opinion for the plurality that says, the real problem in Brown is that students were told where they could go to school based on the color of their skin. And that seems like a proposition that many of us, would agree with. And he says, though, there's not one whit of constitutional difference if the program is telling people where they can go to school based on the color of their skin for the purposes of promoting racial integration rather than preserving Jim Crow. This seems to me to be, the falsest of false equivalences, and sort of maybe works out for somebody on a chalkboard, but not for someone who has been attuned to the oppression that has confronted black people in this nation.
Questions from the audience?
There's somebody just there.
Right here.
Thank you so much. I have a question just about a bit more about what you mean about race qua race. I'm thinking about a sort of hypothetical policy a school could adopt wherein a person can check a box that gets preference in admissions. It says they went to a school that had less than 50% of one racial group. Essentially, I don't know how to put it, but a diverse school, a school that wasn't dominated by one racial group. It's not clear to me at all whether this would, who this is going to help or hurt or whatever, but it made me wonder a bit more about what you meant by race qua race, because it's sort of like you can define it as diversity, but you could define it as, well, a school with less than 50% of a given race. Is that race qua race? And it is an invitation to just say more about race, what you mean by race qua race, and how we would put parameters around that.
Sure. I think that this is going to be something that the court will need to confront in the future about putting more flesh on the bones there. One could certainly imagine, some programs that would be, one might think, difficult for the Supreme Court of the United States to uphold. I don't think that, Justice Scalia would say that a program that says, I attended a Title I school, say, a school that receives federal funds because a large percentage of the students are on, free and reduced lunch, that would be an impermissible racial proxy. At the same time, it is true that there is doctrine out there that in some instances suggests that if the sort of mechanism leads to such a lopsided outcome that might violate the Equal Protection Clause of the United States. I have in mind the cases that would include the Yickwo versus Hopkins, Yickwo versus Hopkins from the 19th century. Also, the Gomillion versus Lightfoot decision from 1960. And there's a case called Hernandez versus Texas from 1954. In all of those instances, the mechanism in question was so lopsided, the Supreme Court says, that this leads us to be able only to conclude that this was adopted for impermissible racial reasons. And so that could be understood as race qua race. But I don't think that any, of the programs that I defined, that I sketched, I should say, should be understood to run afoul of that. Okay.
Professor Driver, appreciate your comments today, and appreciate in particular your suggestions or challenges for the progressive side of this debate as well. And so on that note, I was curious if you could elaborate a little bit more on what justifications you find the most compelling in defense of affirmative action between diversity. You mentioned Owen Fisk, of course, who elaborates on kind of like anti-subordination leadership, development of more racially diverse leadership. At least that's how I think about Fisk's work. And I think there are also a set of theories too, which I'm sure you're quite familiar with, around how we think about racial status as feeding into how we evaluate individual merit. And so I'd be curious what you personally find most compelling among those rationales.
I'll say a few things. Thanks for the wonderful question. One is that there could be some sort of democratic justification for affirmative action, small d. I think I gestured at that with respect to the mighty Yale College class of 1969, that drawing on all of our people and its talents is in the interests of the nation as a whole, and so there's some sort of, democratic justification. I only gesture toward this idea, but thinking about what does the Equal Protection Clause require, what about an integrationist conception of affirmative action related to the democratic justification that I just offered? This sounds like a radical idea, a crazy idea. I borrow it from Justice Lewis Powell, appointed to the Supreme Court by President Richard Nixon, who was the chairman of the Richmond School Board at the time of Brown versus Board of Education and fought that decision tooth and nail. Justice Lewis Powell was no one's idea of a radical. And nevertheless, in the Keyes decision from the 1970s, he says, we need to get beyond this de jure, de facto distinction. And he's thinking about Richmond, and why is Richmond being treated so differently than, Michigan? And he would say that it should be required for school districts with lopsided racial enrollments, with schools with lopsided racial enrollments, for the district to be able to take integrative steps. So that's an attractive constitutional vision to me. It's one that has been lost to time because we're so focused on the Equal Protection Clause is anti-this and anti-that. What is the Equal Protection Clause pro? My old boss, Justice Breyer, says, thinking about the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, that these group of amendments was designed to transform a group of people who had been enslaved and turn them into citizens. And so I think that that's another way to go. The last thing I'll say, I co-authored an article that stood up for the much maligned diversity justification for affirmative action. In sophisticated circles, people hate diversity, right? Justice Powell, his saying that diversity was permissible, that's ridiculous and made up. The idea that people are learning from each other in the classroom and that different people have different perspectives, this is absurd. They're not really committed to diversity. So my co-authors, who are empirically sophisticated, and I am not, I did some of the writing, but they did the number crunching. We did this really, from my perspective, fun experiment where we looked at law reviews implementing diversity policies from the top journals over time. This is something that happened over a long period of time. And we counted citations. Citations they're countable. They're not everything by any stretch of the imagination, but they're helpful. And the reason that we did this, one of the reasons that we did, is that there were some lawsuits at the time that suggested that diverse law journals with diversity policies meant that journals were doing a bad job. And so we said, well, how are you going to count this? And so we actually looked at the citations in the 5 years before the implementation of the diversity policy and the 5 years after the implementation of the diversity policy to say, hey, did these journals go in the gutter? And my empirically sophisticated colleagues thought of all sorts of controls in order to make sure that things weren't changing. That is to say that the diverse journals were not taking more con law pieces that are cited heavily in comparison to bankruptcy pieces. We found a statistically significant increase in citations after the implementation of the diversity policies, and we make the claim that this is actually emblematic of what happens in other settings as well, where you have a group of people sitting around a table trying to figure out what is a good piece and what is not, and that diversity was additive. So I don't feel compelled to hang my hat only on one justification, but that's all three. Do we have time for one more, or is that a wrap, or what? Okay, last question, I think.
Thank you very much for your talk. I think since it is the Derrick Bell Lecture, I want to ask a question at the intersection of legal realism and critical race theory, which is recent decisions by the Supreme Court and others have found a presumption in favor of race-neutral justifications by government officials, for example, in things like the voting rights cases. That where there is a racially disproportionate impact, we should presume that the elected officials who designed the system were actually not trying for racial imbalance. They were doing it for other reasons, partisan gerrymandering, for example. In most of those cases, it's to the benefit of white individuals, right, and that presumption. What is your view around whether the strength of that presumption for race neutrality would apply also for these sorts of efforts to increase diversity?
It's a very good question. I want to think a little bit more about it, but I especially appreciate the thrust of the question, which is to say, let's not forget who we're here to honor today. And so I think I'll just take the invitation, I'll accept the invitation to say a few things about Derrick Bell and my shifting relationship to his work over time. I mentioned encountering his work as an undergraduate decades ago now, Faces at the Bottom of the Well, the subtitle of which is The Permanence of Racism. He had a bleak, one might say, a racially realist conception about the possibility of progress. I would style myself as, certainly in the past, of having been, more on the optimistic side. I reread Bell. I learn from him. I hope that he was wrong, but on some days I fear that he was right.
And hopefully, can we indulge you with one more question since the president has one?
President's rights. President's rights.
Now I'm going to be embarrassed by the question. Should the number of justices on the Supreme Court be increased? And given from an outsider's perspective, the role of precedent and law has been thrown into upheaval. Should what's being taught in law schools change?
Okay, I'll say a few things. So I was a member of the Presidential Commission on the Supreme Court of the United States, which did investigate this matter. I will describe generally what people would say. Some people would say that there are, stolen seats on the Supreme Court of the United States in the form of, my old boss, then Judge Garland, not even receiving a hearing in the aftermath of Justice Scalia's death, even though that happened in the first part of the election year. And the justification was, well, in an election year, we don't confirm Supreme Court justices. And of course, you flash forward a short time later with Justice Ginsburg's death, and only weeks before the election and the installation of Justice Amy Coney Barrett. And so some people would say, this is an outrage, and we need to expand, right-size the size of the Supreme Court in order to counteract that. Critics would say, that is if you do that, pack the court is what they would say, not expand the court, but pack the court. That's a recipe for a Supreme Court with 132 justices. And there's a race to the bottom, and that would be unattractive. Of course, the Constitution of the United States doesn't say anything about the number of justices. It's by statute, and we've had 9 for a very long period of time. Some people are interested in the idea of term limits for Supreme Court justices and whether that would require a constitutional amendment is a hotly debated question. Many members of the commission were deeply sympathetic to the idea of term limits, 18-year term limits. This would be desirable because it wouldn't require or it wouldn't incentivize putting someone on the Supreme Court, right after their 19th birthday, right? You could get people who are a bit more seasoned. Critics would say that the court's supposed to move slowly and incrementally. And if you introduce the idea of term limits, they can do some counting, and it might really introduce sort of rapid jolts this way and that way in the law, and that would be unattractive. The last thing I'll say is, should how we learn in law schools change? My own view is, of course, given the composition of the Supreme Court of the United States. Law is not philosophy. Constitutional law is engaged with the real world. And sometimes I encounter students, when I talk about originalism and textualism and things of this nature, recoil. And I think that's deeply mistaken, because in an effort to retain one's purity, and by not soiling yourself by engaging with originalist argumentation, it seems to me that you might well prevent yourself from being the ablest advocate for the causes that you hold dear. We need to do a better job than we're currently doing of having law students come together and have vigorous disagreements in the classroom, and continue those discussions afterward. It's a very important thing. I do worry about law schools today. In the first week of law schools, people are asked to declare themselves whether they are a member of the Federalist Society or the American Constitution Society. Law school's answers to the Sharks and the Jets. And then they get together and they deliberate with like-minded people rather than people from other places. And there's lots of social science that suggests when you only deliberate with people who think like you actually become more extreme in your views. And that polarization that we've seen in our political world for a long time is migrating into the legal world, and it's one that makes me fear for our nation. Thank you, thank you, thank you.